oversight of the police department. Indicate the NJAC 4A:2-2.6 says that the hearing shall be heard before the quote appointing authority or its designated representative. The city manager does not, but the appropriate authority and city manager by definition do not equal the appointing authority without further resolution. There is no specific resolution, at least none given to me, as required, listed city manager or you by name as the hearing officer in this matter or any other hearing. So I would like to have, move to have this hearing terminated, the charge is terminated because of that. So we do all at once, or do you want to go through one at a time? Chief of police, it's not nothing to do with him personally, but the fact is that the two of you work together, have to work together on managerial issues, and for you to make a finding in favor of my client, you would of necessity have to make findings, not necessarily credibility against the chief, but that would not be in his favor or what he is proceeding or pursuing. He doesn't believe that to be a conflict of interest and would move for you to recuse yourself and to appoint an independent authority as the hearing officer. That's two. Number three, the hearing procedures regarding municipal and disciplinary hearings here in Asbury Park are dated. Discipline overall for the police department's rules and regulations is section 4, I believe it's :1. And there are really no procedures whatsoever regarding how the hearing would be done. That's the fact that we're here today and weren't sure how we were going to be proceeding. There is nothing to indicate how the process works, how it will work in terms of rules, how it will work in terms of witnesses or discovery. There is absolutely nothing in that. Title 11 of the Civil Service provides that governing bodies shall, in mandatory, prescribe rules and regulations for the conduct of the hearing. And a personnel policy, look at other things, but the personnel policies, the employee handbook for Asbury Park, the Asbury Park Police Department's rules and regulations fail to set forth any procedural rules and regulations for disciplinary hearings at all, period. To proceed without such rules, without notice of such rules, is unfair to the accused. It becomes a legal nullity should there be a challenge after the fact. So therefore, I move for dismissing the charges and terminating hearing on that basis. Fourth one, there has been failure to supply complete discovery in this matter, unless I've been moving for dismissal of the charges. Charges were proffered against Captain Love, as you recited earlier, on, I believe, August 5th of this year, 2016, by a letter dated August 15th, 2016, as counsel for Captain Love. I submitted a 5-page demand for discovery with very specific demands. I also sent 2 follow-up letters, one of which I received a response for. Follow-up letters, this first one I got a response from was essentially all references to no, we can't have that. And that's the 5-page discovery packet I did receive. For instance, that I believe I received the rules and regulations of the department. I received, I'm not going to list all of them, just to give you an idea. I received the ordinance information, which I've already discussed, as well as my client's personnel records. Those kinds of documents. I did not receive any substantive documentation in terms of internal affairs reports, things of that nature. I did also receive, however, a disc, which I believe was created by the Monmouth County Prosecutor's Office as part of its review of the circumstances surrounding the Sidell shooting on June 16, 2015 here in Asbury Park. There were no specific things provided by Asbury. There was a homicide that occurred here a few blocks away, obviously.
Sorry, I didn't get that.
A few blocks away, 14 months ago now, 15 months ago now. It was a joint investigation, as all homicide investigations are, between the county prosecutor's office and the municipality in which the event occurs. Thus, the Asbury Park Police Department would, by definition, have copies of all the documents pertaining to the homicide. Now, I understand that some of those documents might not be relevant, but that's not for anything that would be decided, decision for you to make should someone try to use them. However, in terms of trying to properly defend my client and his rights, I should have the opportunity to review those and make that decision and have the opportunity to bring those to your attention and what you could rule upon whether or not there was relevance. I didn't have that opportunity. I do not have any of those documents. What I do have are documents regarding police reports and some statements pertaining to a review of police action in this manner. And that's it. There is supply the documents that I have requested, which are relevant at least for purposes of review prior to a hearing, constitutes a deprivation of my client's due process rights under the state constitution. And as a result of that deprivation, we cannot be properly, and we are prepared to move forward. We cannot be properly prepared because we have not reviewed everything, because we have not provided all these things, and based on that, the charges should be dismissed. Next, item number 5, an application under NJSA 48:14-147, 45-day rule. I'm cognizant it does not apply to all aspects of the charges pending against my client. However, at a minimum, it does apply to the accusation of a rules violation of the policy of the Asbury Park Police Department for a term. Rapid response to active shooter. That is purely departmental regulation. The 45-day rule, without quoting it, requires that the administrative agency move forward with charges against the individual within a 45-day period after they've received sufficient information to move forward. This case is 15 months old. Everything that they've accused my client of doing as being improper, they knew about within a minimum 2 weeks of the event, yet nothing was done. At a minimum, those charges, those accusations of violation of that, are a violation of the 45-day rule and thus should be dismissed out of hand. We should not have to even face those at this juncture. Lastly, it's my understanding from a discussion with counsel, and I appreciate his candor when I asked him for a witness list, that he was only going to be calling Chief Salerno. And that the evidence they were going to be relying upon was essentially going to be a compilation that's prepared by the Monmouth County Prosecutor's Office in their review of the police action on the day of June 16, 2015, involving the Salerno homicide and shooting. The problem with that is that it is complete, utter, total hearsay. I realize we're not in a court of law, but nonetheless, hearsay rules exist for a reason. The reason hearsay rules exist is because each person who stands accused has a right to challenge his or her accuser. No one can challenge a piece of paper. So for someone to sit there and read reports or documents or describe the contents of those other documents without having the opportunity to challenge the person who uttered those phrases or came to those conclusions is nothing but pure hearsay. There is a residual hearsay rule that allows such things, but is not recognized in the state of New Jersey, and if not proper, it would be a gross violation of all evidence rules in a state that was allowed to do that. And then without any exceptions to the hearsay rule under rules 803 or 804, there was no way for my client, through his counsel, to challenge the accuracy, the memory, the credibility, or probe any information whatsoever as to the information related by a single witness called by his court relating to someone else's investigation essentials. That is a violation of his fundamental rights and due process under the state constitution. Thus, those charges should be dismissed. That is what the city is going to do in terms of prosecuting this matter. As the entirety of my motion, I thank you for your response to one aspect. That's the 45-day rule. Mr. Gledman says that when there's an investigation and it holds it. It's true. However, that's when the underlying charges that are administered against that police officer are being investigated as criminal conduct. There is absolutely no indication anywhere in the prosecutor's office throughout this entire process that Captain Love was being investigated for criminal conduct. That's where the tolling aspect comes. There was only the review, the policy review by the prosecutor's office. Then the criminal prosecution was against Mr. Seidel. That does not toll the administrative charges, have not to do with the administrative code. The administrative charges are rules and regulations for the captain. That's separate and apart. Not any investigation, a criminal investigation into his conduct and his conduct only, and there was no such investigation.
Okay. Both sides just brief it.
Coleman, do you want everybody sworn in?
Yes, I will, please.
Do you swear to tell the truth, the whole truth?
I do.
Good.
Please state your name for the record.
Anthony Salerno Jr., Deputy Chief of Police, acting as the Chief Executive Officer for the city's police department since September of 2014. It also said that the Monmouth County Prosecutor's Office made a decision to supersede the internal investigations.
As to his conduct.
just refer to what it's indicated in.
Oh, it said that the Monmouth County Prosecutor's Office supersedes.
Objection, again, it's got nothing to do with his conduct. What they didn't do doesn't matter.
Okay.
He's asking for the conclusions as to his conduct.
We'll go beyond that, that's fine.
Asbury Park has to make a determination about what Captain Love didn't do, and whether or not it was improper, not the Monmouth County prosecutor knows. We're not sitting in free. Prosecutors aren't here.
That's true, but if Chief Salerno said it was based at least in part upon their recommendation and their findings, it's important for you to know what he based his decision on.
And again, the nature of my hearsay objection, he's doing this entirely based on someone else's report, and someone else's findings. And I doubt seriously his personal knowledge that the prosecutor personally wrote that document. He signed it, I'm sure.
The reason and the rationale behind the penalty would be that I can't have Captain Love as a commander. He needs to be at a supervisory position, but not a command level position.
For Captain Love respond to an active shooter situation with a man in the street who at that point, no one knows what he's doing, is firing shots, or has fired shots when he gets there. A little girl that he knows personally is brought to him, he spirits her away to get her out of harm's way, and that's why he's in trouble. We'll come back to that.
We're going to be making statements, or are we going to be asking questions?
Well, answer the question. Answer the question. Answer the question.
There was no question mark at the end of that.
There's a question mark now. He's in trouble for responding to that scene, taking a little girl out of harm's way. Correct?
He's in trouble for leaving the scene of an active shooter.
By taking a little girl away from a dangerous situation, correct? That's why he left the scene the first time, correct?
Judgment on that decision is faulty and poor.
Did he or did he not leave the scene to take the little girl
He did.
away from a dangerous situation where bullets had just flown?
Where the
That's
girl
real simple.
was not a dangerous location.
You have 7-year-old girls within 30 or 40 yards of a shooting scene, you think they'd still be safe there? Would you do that?
I know the distance and the number of cars and the number of police that were between the active shooter based on the Monmouth County's investigation.
And you know how bullets go. Bullets don't go the wrong way.
They do.
In Asbury Park,
They do.
in other cities, in other towns, people get hurt that aren't even at the scenes, correct?
And there was a lot of people there, including police officers and civilians, that were not removed from their houses, that were not, the officers were
There's no
not.
question pending about the other people. There's a question about the little girl. He
Well,
took the
wait a
little
second.
girl
No,
away.
wait a
and-
You've
It's
asked
part of my
me.
answer.
He can't just answer questions that aren't asked.
There's a question about an unsafe situation.
No, the question was the intent, and he's talking about other persons in other home. I'm asking about whether the little girl was taken away to get her out of harm's way. It's a simple question.
The answer is yes.
Whose idea was the charge?
It was my decision to charge after receiving the report of the Monmouth County Prosecutor's Office with their recommendation as the chief law enforcement officer and agency of the county.
Yeah. Who decided to punish him? Proposed punishment.
I did, but I also spoke with the labor attorney, Steve Whip.
Anyone else?
No,
Previous punishment for Captain Love. What's a good punishment when passed? What kind of punishment has he received? 20 years in service.
I don't know.
None, right?
No, I can't say that. He does have files, I don't know what's in them.
That wouldn't matter to you in terms of determining what the appropriate punishment was?
Not in this case.
And your rules and regulations, 1:6-1, one of your primary mission, elements of your mission statement is to safeguard lives. Is that not correct?
Correct.
Now, on June 16, 2015, the day of the shooting here in Asbury Park, Ms. Seidel, you were working that day, were you not?
Yeah.
You went to the scene, correct?
Yes.
And did you receive advance warning that that was going to happen?
Day before, I was invited to go to the public briefing, and that was it. I received no advanced information as to the outcome or to the nature of the findings.
Or you were provided with the findings there or in advance?
On the day of the hearing, I was sent an email with some basic information that was in the press release. Other than that, I received no information from them. That came much later.
I'm sorry, what came later?
Information regarding the extent of their investigation, the statements, the videotape.
And did you discuss that with the present city manager?
No,
You didn't discuss the findings of Monmouth County Prosecutor's Office about your entire police department that was made public to the world in a press conference. You didn't discuss that with the city manager.
not in any detail, no, just,
What
it
is
was
not-
pretty, it was public.
You discussed it with him, or you didn't discuss it?
No, well, I don't recall if we had a conversation pertaining to that, because it was pretty well known, it was in the paper, it was on TV, it was just about everywhere.
So you had a discussion.
I would say so, but not to any great extent, no.
Did you share with him your conclusions about what had transpired and what should happen next?
No,
In terms of the investigation, how many witnesses did you interview?
none,
How many were you a witness to the interview?
none,
How many witnesses did you observe being interviewed?
none. Except, well, unless you're counting me, and I was interviewed, took a statement, but other than
We'll
that,
get to you being a
excluding
witness.
me, yes.
We'll get to you being a witness in a couple of minutes.
Okay.
Did you work this case, either case, the homicide or, in your experience, detective, did you work this case, either case, the homicide or the review with any of the prosecutor's office detectives?
No,
When the prosecutor's office declared itself done and had its press conference, did you assign an IA investigator to the case from your department?
no,
Are you aware that the prosecutor's office, in terms of its published review, determined that certain persons, whether they be public officials or private citizens, information was irrelevant to the review of the police contract? It's in the report. Who said that?
it's in the report.
Did you independently assign someone or yourself, go and speak to those persons that the prosecutor's office determined were irrelevant, to determine if that was accurate?
No,
So, as you sit here right now, you have no idea if that's accurate or not.
no,
Now, there were members of other law enforcement agencies at that scene, correct?
there were,
Numerous.
yes,
Other municipalities, right?
yes,
County agencies, including the prosecutor's office, the sheriff's office.
there were,
Were there, I don't recall, were there any federal officers there? Were there federal,
Yes.
okay, federal officers as well?
Marshall,
Marshals, U.S. Marshals. Did you speak to them?
no.
Their statements weren't included in this review, right?
I never received anything, any statements from the other agencies.
Now, is it not true that, for all intents and purposes, the only individual eyewitness to all the events leading up to the past, the first shooting, was the young girl's 7-year-old daughter, correct? The police, the chase, the crash, the
From the
shootings.
beginning of the chase, yes, you're correct about that. Mhm.
She gave a forensic interview to the Monmouth County Prosecutor's Office. You know what a forensic interview is?
I do.
Your experienced detectives in the past, right?
Mhm.
Which means that someone with experience in speaking to children sat her down on video and spoke to her at length in a manner that she can elicit, or he can elicit, the information from this child in a way that's not threatening and that does not upset her any more than the events themselves would upset her, correct?
Correct.
All right. Why didn't you give that to me?
I didn't get,
Did you ask for it?
no.
Did you
I didn't
review it?
know they did it.
You didn't know they did it?
No.
Did you review the documents
I did.
provided by the prosecutor?
I did.
It's right in there.
Okay.
Same documents you gave me. You didn't know. And the
No.
only eyewitness in this case gave a statement and you didn't know it, never mind, look at it.
Eyewitness of the chase?
She also was there for the first round of shots,
Yeah.
correct?
Correct.
She also could provide information, could she not, if she was asked questions as to how and why she ended up with the first responding officer in fairness to him, was basically by happenstance, and before him, was almost hit by a car, and by Captain Love, the third responding officer, hence the designation APPO3. Right, and how she got into her car, and how she felt about it, right?
Right.
But you don't know that.
No.
You brought the charges, she's the only person who knows about it, she can provide you relevant information about exactly what you brought charges against him for. If you didn't know about it, you didn't pursue it. Now, as I read your rules and regulations, your department has adopted the Attorney General guidelines, is that correct? Sorry, pardon me, it's too vague. The Attorney General guidelines for internal affairs investigations. You've essentially transported them into your policies, correct? And you understand, of course, on that, part of that process is that you have to select and create an IA unit. Do you have an IA unit? Who's it comprised of?
Lieutenant, sergeant, and police officer.
So 3 persons.
Yes.
And there is a specific section in there, I'm referring to page 13 of the Attorney General Guidelines for the council first. It's titled Selection of Personnel for the Internal Affairs Unit, correct? And then in the very last paragraph on that same page, council and chief, it says, law enforcement executives shall not assign to the Internal Affairs Unit any person responsible for representing members of the collective bargaining unit, correct?
Yes.
And it goes on to say, the conflict of interest arising from such an assignment would be detrimental to the Internal Affairs Unit, the subject officer, the person so assigned, the bargaining unit, and the department as a whole, correct?
Correct.
And the purpose behind that is rather plain, that the person who's involved with the collective bargaining or union has a duty and obligation to the members of that union, isn't, as our brothers and sisters, correct? Thus there will be a conflict of interest built in, correct? And one of the reasons that that's done as well is so the public can have, believe that there's integrity in the process of internal affairs actions, correct?
Yes.
One of the criticisms, as you know, experienced police officer, is that people don't believe, even though it generally works, that police departments can police themselves, correct?
Yes.
So one of the ways to do that is to avoid the appearance of impropriety by keeping union members or active union members or officers away from the IA process, correct?
At this point, I'm going to object as to the relevance since the IA unit wasn't involved in the investigation.
Is there a question?
There's a question coming that's pertaining to this, but the fact that the IA unit wasn't, is completely relevant, because the IA unit, in our opinion, in our position, should have been involved. And that's what we're examining right now. So the question is this, at this point, with that, is the converse should be true as well, right? That the appearance of propriety and fairness not only goes to the public, but also goes to the accused, correct? There has to be some, I'm sorry?
Yes.
Fairness, right? The word you said. And you, as the chief law enforcement officer in the city, you made a decision and the conclusion is to move forward on the charges without an investigation, without assigning someone else independently. You would be the exact polar opposite of the union members. You'd be management, correct?
This is argument. This is not relevant at all to the conduct. I don't understand where we're going with this.
Is there, I agree, is there a point with this?
Yes, the relevance is that he's making decisions, all right? That he was, we'll get to, we'll move on. Have you ever been an internal affairs officer?
Yes.
Did you receive training?
Yes.
Where?
County Prosecutor's Office.
When?
Back in 19, when they had horses here. Let's see, it would have been 1999, 2000, 2001, right in that area.
Any refreshers since then? And you know that the rules that your department has adopted says that all serious complaints, you would agree this is a serious complaint, correct?
Yes.
Shall be forwarded to the Internal Affairs Unit, correct?
Yes.
Did you do that?
No.
Third paragraph on page 21 says, does it not, the Internal Affairs shall notify the suspect officer in writing that internal affairs investigation has been started, correct? Unless the nature of the investigation requires secrecy, correct?
Right.
You didn't provide him with notice of that, did you?
County did the investigation.
Did you provide Captain Love with notice that he was the target of an internal affairs investigation?
It's already been
There was
testified, there was none.
There was no internal affairs investigation. I don't see how it's relevant.
The relevance is that there should have been one independent of this, that it's required by the guidelines that this department and city has adopted itself. You can't discard them when it's inconvenient or somebody else has done something. You still have obligations to follow the same rules and regulations you've adopted. It also requires that complaints must be professionally, objectively, and expeditiously, investigated, correct?
Yes.
Do you consider this to be expeditious, 15 months?
If the chief law enforcement officer felt it was expeditious, then it was expeditious.
In this instance, you were the charging officer, correct?
Yes.
And for all intents and purposes, the IA investigator, correct?
No.
You were the facilitator for the IA investigation, correct? Or you're not testifying about what they found?
Yeah, I'd like to know what you mean by facilitator in this context.
You were also, as you mentioned earlier, a witness, correct?
To the events at the scene? Some of them, yes.
Well, you were interviewed by the Monmouth County Prosecutor's Office detectives, correct?
Sure was.
They believe it was a major crimes detective, temporarily detached and put back to professional responsibility unit, which normally conducts investigations of police misconduct, correct? Specifically, you were interviewed this is a report, Detective Ryu, R-Y-U, Washburn, W-A-S-H-B-U-R-N-E, the Monmouth County Prosecutor's Office report dated 7/31/2015. I'm going to make reference, Mr. Manager, to the time and the date on the top of the first paragraph, because there's multiple reports from the 31st. But it is also the one that involves.
We'll mark that D2.
Thank you very much. Have you seen that before, Chief?
Oh, yes.
You have?
Yes.
Okay. This is one of the documents the prosecutor's office provided that you
Yes.
provided to me, correct?
Yes.
And this talks about your interview as a witness,
Yes.
all right, involving this investigation, correct?
Yes.
And looking down at the bottom of the page, there's a section here near the bottom that says that you were with Detective Daniel Kasluk. At the time, someone, presumably a police officer, asked you if they should attempt to tackle Seidel, and that you said no, because it was too dangerous, correct?
Yes.